thank you. My name is Bill Lacey. I'm with the Association for Corporate Health Risk Management, acronym for short. This is our third panel for the second Aspirational Healthcare Conference. So we are thrilled to continue this conversation. I did want to make note of the other two panels, just in case people may have not been involved. The first one was the employer panel, taking control of your plan, partnering with providers, and empowering your employees. And the second panel, attention employers, and that's with a big emphasis, how to avoid your employees filing class action lawsuits against plan fiduciaries. This is the CEO, the CFO, Chief Operating Officer, Chief Human Resource Officer, among others, who will be standing in line because you all are involved providing a fiduciary role in managing your employees' money when it comes to self-insurance. But today, or this could be a couple hours later, we are going to be focusing on another element from a legal standpoint, and that is we're calling this session Legal Update, Patient Surprise Billings, Hospital Monopolistic Practices, and this is happening across the country. And we are quite thrilled to have two experts to talk about this. We have both a leading attorney with ERISA and class action experience, as well as a consultant who actively followed a case in Colorado. Doug Aldine, who's based in Austin, Texas, is our healthcare attorney and serves as general counsel for a couple of different firms. And then we have Frank Stichter. Frank leads a firm called Strategic Health Plan Consulting. For those that have been attended our other panels, Frank is a veteran for us. And also, Frank and I were on a panel last year. I want to get things started with just giving a couple of introductory comments here, and this is going to operate as a 45-minute moderated panel, and I'm going to add a couple of tidbits in this conversation. But one thing that we're going to focus on with Doug is a class action suit that's happening in North Carolina. Frank is going to share the results of a case that has gone through the Colorado court system and reached the Supreme Court. And there may be other cases, things that we want to talk about. And the reason we're bringing this together, it touches some of the themes of the conference: alignment, patient-employer choice, and relationship. Managing a self-funded plan is a critical piece of that. So that's why we want to bring this forward. I had served as I was the first corporate risk manager for Pico Energy, which today is Exelon, the largest power supplier in the country, and this was a critical area. We started the development of corporate-wide risk management back in the late 90s as a result of deregulation, and boy, there was an awful lot of concern. The dollars were significantly higher. Our risk on an hourly basis was anywhere upwards of $500 million. But healthcare for even small employers is a big number. So we really want to pay attention to these two experts. So Frank, to get us started, can you please share with our audience exactly what is a surprise bill or a balance bill? What are we talking about when we talk about these concepts?
Well, balance bills and surprise bills have been actually occurring for quite a while. A balance bill, I think, and people get them all the time. And I've got really two different definitions of that. One is that what you use with a traditional PPO, where by an employee or a member has a service, a medical service. Claim is adjudicated by the administrator. They get an explanation of benefits and says, this is what you owe. And presumably they're going to get a corresponding bill from the medical provider that equals that amount. As I said, in a traditional insurance setting. Now, when we start talking about other payment forms, such as reference-based pricing, those two, the EOB and the bill, may not match. And that's what we're going to talk a little bit about later. The surprise bill is really referencing, typically non-network type services, and an employee not knowing or a member not knowing what the cost of those services are. So it occurs all the time. It's just in what way, shape, or form does it confuse the member?
And Frank, I know ChargeMaster seems to be a concept that potentially establishes some in the pricing mechanism. Can you give us a little background in the ChargeMaster?
Sure. I think this is fundamental for anybody understand what the heck is going on. Generally speaking, for a business, 9 out of 10 claims that come in the door to be processed and paid are physician claims. The other is a facility claim. Generally speaking, we'll call it a hospital claim. But that can represent 65% of the total annual cost of the plan, notwithstanding prescriptions. So what's going on with that hospital claim? Well, every hospital has what's called a charge master. Every hospital's charge master is different because they all offer different services. But it's a voluminous file of everything that hospital offers you and I when we walk in the door. It's everything from ibuprofen to the ICU and its related price, its related cost. So when a PPO comes in, an insurance company PPO comes in and negotiates their PPO discount, I call it top-down pricing. It's a discount off of billed charges. It's a discount off that charge master. The problem we have in this country, and Doug knows this firsthand as well as do you, Bill, there's no laws, no rules, no regulations about what the prices can be. The sky's the limit, the CFO's limit. So it's problematic. So if an insurance company comes to me and says, hey, sell our program, we got the best discounts going, my cynical response is discount off of what?
Exactly. If you let me set the price, I'll give you a 99% discount every time.
There you go.
Yep.
It sounds like going into a shopping mall or a retail clothing center where suddenly we see a 60% clearance sale, but again, 60% discounted off of what? They could have marked the prices up the day before or that morning. So another market situation I would bring into the discussion before I pivot over to Doug is health systems, as I like to say it, health systems are either acquiring, being acquired, or shutting down. And what we're seeing here is a consolidation in many, many, many markets across the country where we used to have multiple health systems. Now we're getting down to maybe 1, 2, possibly 3 in some of the larger markets, but which is driving prices up. And there's, again, I'm calling it pricing, but we don't really see what the pricing is as consumers. It's something that happens after the services are being provided. So, Frank, what are you seeing in terms of pricing, quality of care? What's happening right now with health systems?
Well, I'm in, I reside in a rather rural area, and some of these little county seat hospitals are struggling. And the only way that they can afford to keep their doors open is to continue to raise prices. We're seeing a consolidation with acquiring physician practices. That's happening everywhere. I'm originally from Northwest Ohio. There's a hospital system there that's very large, a large regional, and they just keep acquiring county seat hospitals all around the area. So, we as patients have no ability really to shop. I mean, unless we want to go geographically somewhere else, but if we want immediate care, you're pretty well locked into that particular system that serves that geographic region. And there seems to be less and less, as you said, competitive forces out there that to drive costs down. So I don't, I don't see, I mean, post-COVID, we've all heard about that with services needed that are going up that were neglected back in COVID, inflation, higher prices, fewer positions in the hospital. I mean, it's getting to be a perfect storm. And it's, quite frankly, in my opinion, it's become unaffordable for members and unsustainable for businesses. It's out of hand.
Well, thank you, Frank. We're going to come back to your experience in Colorado in just a minute, but I want to bring Doug into the conversation. Doug, can you share with our audience what function does an ERISA attorney play? What role do you serve out there?
Yeah, it's funny that you asked that because, I've tried explaining to my parents, like, what it is that I do, and they're like, I don't understand. There's a lot of things, just understanding, what the arrangements are. I mean, so I've had the benefit of just understanding all the different contractual relationships. I mean, the ASA agreement, between the plan and the TPA, the summary plan document, which is your governing, subscription certificate or policy of coverage, the stop loss stuff. But, really a ton of what I do is leveraging the fact that a plan is self-funded and resolving disputes, particularly with facilities. That's probably 90% of what I do. And, as an example, hospitals 9 times out of 10 will never appeal timely, and exhaust those administrative remedies under the plan, which gives you the standing to ask the plan for more money. Because remember, you're taking that assignment of benefits from the member or the patient. So, they're stuck solely looking to the patient for financial or, to pay the bill. But it's a great way to honestly leverage that particular arrangement and use it to the plan's advantage.
But thank you, Doug. That helps. Now I want to scratch a little bit deeper here. Why and how did you organize and pursue the class action suit against North Carolina-based Beadon?
Well, you think about this, and so there's a law firm out there that I'm very familiar with, Mona Wallace, who's a great lawyer over there. Really what we have in this country, it's not a balanced billing problem, it's a billing and collection problem. And it's out of control, and whether the bill is, I mean, it's pretty common for bills, I think 90% of bills have some error, in it. But, hospitals can leverage that through their collection practices to truly, extract and exploit from patients who, think about this. You're in pain, you broke your leg, you want somebody to help you, you're getting gouged, by the facility. And it really is, it's one of those kind of things where if we can make something like this stick, I mean, how many other health systems operate in the same fashion? A ton.
Mm-hmm. And I guess from personal experience, it's looking at your scenario. I broke my leg. I'm in the hospital. I'm signing all kinds of forms, one of which is, hey, whatever your insurance doesn't cover, you're going to be liable for. But right. You haven't given me any idea of how much is it going to cost me. You're just going to be liable for all of it. And
right.
If you don't sign it, there's the door.
That's right.
So
pretty much.
So go a little bit further. I mean, how did what's happening with Beadon? How do you put together a class action suit?
Well, you put it together just because, a lot of it's serendipity, where you have, like in this particular instance, the member was basically being balance billed 11x Medicare, and the guy was, had a financial background, and it was a reference-based pricing plan. He knew exactly what was happening. So, he was, what I would call an ideal plaintiff. I mean, understood what was happening, but didn't appreciate it happening to him. and was willing to, step forward and be a named plaintiff. But there's a ton of people out there like that. And, most people, I mean, they give up, they're overwhelmed, don't understand really what's happening in terms of, why is the health system doing this? But yeah, so you're just lucky that way. But again, if you can make it stick, I mean, it's one of those kind of things that you can, basically, franchise it just across the country. That's ultimately the goal.
And so where are you in the process? Has the case settled, or are you still?
Oh no, oh yeah. I mean, think about this. I mean, it's just getting started. So it was only recently filed in February.
Okay.
So yeah, you're getting, answers from the hospital on file. I mean, you've got the big law firms coming in. So it's really, the engine is just now starting to turn. So a lot of game to play. I mean, it's 1st and 10, on the 20-yard line, first quarter.
Okay. Interesting. Well, thanks for sharing that. So Frank, from your standpoint, Doug's just starting, but the case that you're going to talk about has gone across using the football analogy here, has gone across the goal line. So Frank, take us through the history of that case.
Sure. And I'd like to reiterate what Doug said. A lot of people do give up. They just don't have the fortitude to hang with it, like Mrs. French did, or Miss French, that we're going to talk about. So, and I also, like Doug, when I was trying to explain what you do to your parents, somebody asked me what I do, and I said, this is going to be a long and complicated answer. And I said, I try to get people to do what they don't want to do. And they said, what's that? And I said, change. Because that's what's really needed in this whole industry. So this is an actual situation that ultimately went to the Colorado Supreme Court over a course of 8 years. So Ms. French had a car accident way back 10 years or so ago and needed spinal back fusion surgery. She had it in 2014. The largest hospital system in Colorado is called Centura. They're mainly on the Front Range, but they have a couple other hospitals on the western slope. But when she went in, she was told that she would owe $1,300. They estimated that her bill would be about 57 grand. She signed what you referenced earlier, Bill, the 5 or 6 pages of the hospital service agreement and the Bill of Rights. But like anything, that when we buy a house or buy a car, we don't read every word of those contracts, because, I mean, she consented to the surgery. She was in agreement. She said, I'll put the $1,000 down on my credit card. She ends up staying for 4 nights or 5 nights, and the bill was $303,000.
Wow.
The bills were audited and repriced, and Centura was paid $74,000. And to the point of balance billing, 3 years later, she gets a balance bill for $229,000. That's where it started.
Hey, Frank, just real quick. So was the $74,000 payment, was that the original payment by the plan?
Yes.
Okay.
Yeah, 74. I'm 74 and change. Yeah. There ultimately was another $770 paid, but because she did stay an extra morning. But so as this goes on, she's going to be sued by Centura. So it ultimately, and Doug knows the firm that we're talking about, and so do you, Bill, that basically is defending her and the plan. It ultimately goes to a jury trial, and the jury, and I'm going to read this, and this is why I brought in the charge master earlier. This is the opinion from the Supreme Court. The jury ultimately found that the term all charges of the hospital meant the reasonable value of goods and services provided to her, and not the charge master rates, and that the charge master rates billed to French were not reasonable. So that was the jury.
And just to pause you there, Frank, the charge master rate was 330,000.
303. But
303, sorry.
where this got to be contentious is when she signed those documents, was there reference to the charge master, either in writing or just in reference? And that's what Centura was trying to argue, was that even though it didn't have a number and it didn't refer to the charge master, that all charges by the hospital referred to that charge master. Mm-hmm. So she had not consented to that. She didn't even know what the heck a charge master was. So, right. There was just no reference to it. So to Doug's also point that when they got to this, and I'll come back, but of that $303,000, $191,000 was related to just the implants.
Wow.
And the attorneys, when they got, when they dug into this and got it, they found out that Centura only paid $31,000, but marked it up 674%. Yeah, I mean, it's crazy. So Centura appeals the case, and the appellate court overturned the jury verdict and said that the HSA and the Bill of Rights did, in fact, make reference to the charge master. So now this has gone on. This is now in March of this year. Both sides pled their argument to the Colorado Supreme Court. It went all over an 8-year period. I mean, this is as Doug, Doug, has this ever happened anywhere that you know? Any state Supreme Court?
Nope. So
they defended this till the cows come home, and it's quite interesting. It's on YouTube. You can actually see it on YouTube. And the opinion's 24 pages. But in the application statement, the court said, moreover, as courts and commentators have observed, hospital charge masters have become increasingly arbitrary and, over time, have lost any direct connection to hospitals' actual costs, reflecting instead inflated rates set to produce a targeted amount of profit for the hospitals after factoring in discounts negotiated with private and governmental insurers. They upheld the jury verdict, and I'll read you 2 other little comments here. It says, this is the very first page of the opinion. The court now concludes that because the patient neither had knowledge of nor assented to the charge master, which was not referenced in the hospital service agreements or disclosed to her, the charge master was not incorporated by reference into the hospital services agreement. Accordingly, the hospital service agreements left the price term open, and therefore the jury appropriately determined that term. So what the jury did is they evaluated the costs and actually said that $74,000 represented fair and reasonable value. And in that YouTube video, and I'd never seen the Supreme Court interacting with attorneys and whatnot, but it's highly interactive, as Doug probably knows. I mean, they're firing questions left and right. And at the end, the last justice asked the Centura attorney, did Centura lose money on the $74,000? And he said no. So it's because that charge master, to understand, as Doug has pointed out and what I've said, it's ambiguous, it's overinflated, it's arbitrary, and it's just crazy. And in talking to the attorney, do you happen to know of Ted Lavender, Doug?
Yeah, I know Ted. Yeah.
Okay. Yeah, he's speaking at a seminar I'm doing at the end of September.
Okay.
But the comment was, while the court didn't expressly state what is fair and reasonable value, he said it's implicit that in that opinion that hospitals just aren't going to have free reign to charge whatever they want, at least starting now in Colorado. So it is a big door opener for what Doug and I mentioned, reference-based pricing. And that's a whole nother conversation. But in simplicity, it's simply, instead of this discount off of what, we're using a reference point with which to base pricing to reimburse providers. And
So
it's usually either a cost plus or Medicare plus.
So you've covered an awful lot here, Frank. Let me see if I can summarize it. So Miss French was in a horrific car accident and needed to get spinal surgery back in 2014. The original bill was $303,000 and some odd change for her 5-day stay in the hospital and for the surgery. A group was engaged to reprice this bill, and they came up with a dollar amount of $74,000. That $74,000 was paid to the hospital. The hospital accepted it. However, 3 years later, a balanced bill comes to Miss French of, you owe this other, whatever the difference was, $229. And I would imagine there was all kinds of aggressive approach on that, like, we're going to send you to collections, we're going to do, you got to make this payment. So
in some of the, I did in talking to the attorney, in some of the depositions, the hospital he said that Centura actually tried to blame her for all of this because she didn't read the contracts.
Okay.
I mean,
how would you read the contract if you're coming in there after a car accident and you're arguably, under some type of sedation? I mean, well,
I mean, she said that her comment was she had acknowledged she didn't read it because she consented to the surgery. She said, "I'm going to pay what you told me I owe."
Yeah.
So, I'm in serious pain. Please help me. Right.
Yeah. Yeah. So I think a lot of
people. So it goes in front of a jury trial, and the jury finds in favor of Miss French, and then it got bumped up to an appellate court, and that court found in favor of the hospital, and then it got bumped up to the Supreme Court, and the Supreme Court found in favor of what the original jury trial had found. And so Ms. French is essentially whatever was paid, and the hospital made money on that payment, that there was no further obligation.
Right.
But that was a 8-year process that she had to endure. So this point that you brought up earlier, most people will fold the tent and will try and find a way to make these payments, whereas in reality, they need to. There's aggressive billing practices that are going on.
Yeah, I think that point needs to be stressed, because how many people would have given up, and just because not only of the time, but the amount. I mean, try to come to some settlement or whatever. But, the plan that she had and the party that was used to reprice and defend, I think helped her with her intestinal fortitude to stay with it and drive home the point. But it is, I think, a landmark type of decision. And while the court expressly stayed away from, and as the attorney said, if you're not asked the question, you don't render an opinion. But they were not asked the question to determine what is fair and reasonable value. And Ted and his partner, Chris, are looking forward to hopefully having that opportunity to do it again. But it's a long process. I mean, no question.
Yeah.
So we've got about 10, 15 minutes left. So I want to talk about sort of what do we learn from this, and what are our steps forward? So coming back over to you, Doug, based upon what you've learned in going through your experiences here, what advice can you offer to employers, to employees, patients, and the health systems and medical providers?
That's a good question. And I think, first and foremost, you know, financial assistance is always available. Now, I don't know the details in terms of what happened with um, Centura and whether they appealed appropriately and timely with the plan, but obviously they were suing Ms. French, so I'm assuming that that wasn't an option. But I would think financial assistance in some capacity would be available because there's a huge issue inside these not-for-profit health systems where, you know, you're a tax-exempt entity, but the level of charity care, because that's what you give up in exchange for your tax-exempt status. You agree to provide a certain level of charity care. And you know, the reality is that the level of charity care, which should be provided at the facility's cost rather than the charge master rate, pales in comparison to what they're getting in terms of tax exemptions. And so, you know, that's always an option for patients. And it's, you know, and you've got different levels of financial assistance. You've got, you know, whether you fit within the bandwidth of the FPL, whatever that policy provides, but there's also medical indigency. So, you know, you could be, you know, the NBA player with the $5 million claim that, you know, would cause you financial problems. So you could be eligible in that capacity as well. I also think that
I want to pause there a second. You mentioned FPL, federal poverty level is what we're talking about. There's a percentage levels off of that, and I think it goes all the way up to maybe 500% over the federal poverty level, that these not-for-profit hospitals are obligated to provide financial support. But what we've discovered is this seems to be hidden in a vault somewhere within the hospital. They're not really open about talking about these this particular support, although they are obligated to provide that.
That's correct. You know, and I think the other thing that, you know, patients can do is, you know, I don't know if you guys know Al Lewis, but he's got a, you know, prevent consent, and you basically sign the admission form, which is I agree to pay up to 200% of Medicare. So you scratch it out. I mean, you've got to be, you know, in the right mind, but I mean, it's a way to set up that defense in the event that there's some type of balance billing issue down the road. So those are two things I think you can do right off the bat that I think have significant impact in terms of the leverage of how those things, you know, with the hospital.
That's some good advice there. Why don't we say that one more time, Doug?
Sure. So, you know, when you go into the hospital, I mean, you can actually sign, you know, the admission form or the consent form and say, listen, I agree to pay up to 200% of Medicare.
Mm-hmm.
Doug Aldane. Yeah, and so you're setting yourself up so that I agreed to pay this. You know, we never had a meeting of the minds here. This is what I agreed to pay.
Right.
You know, so you don't really have a contract. I mean, so again, it's going to come down to what's that reasonable value, and I can tell you what, it's not the charge master rate. Won't be, can't be, never will be.
Great advice. Well, thank you on that. So coming back to you, Frank, what do you see future cases following a similar pathway as what had happened in Colorado? And what advice do you have for employers and patients?
Well, my advice to employers is you got to jump the tracks here and really get engaged with a reference-based pricing program. You know, especially in this day and age of a tight workforce, you know, that you can actually save enough money in it to actually beef up your benefits to make those benefits more attractive to future hires and to retain those that you have. You know, this Supreme Court case is, you know, I don't know if the right term is unprecedented, but I think it really is. Just, I mean, Doug mentioned he didn't know of any others that go to this level. It's very rare that these things go that far. Usually some kind of settlement is reached. You know, the odd thing here is with Centura is they were trying to collect $229,000 over 8 years. Their legal fees were multiples of that number. So, you know, I think it's also on the flip side, you know, are the hospitals going to change their tact to avoid this in the future? What sort of gamesmanship is going to go on there? But you know, the clients that I have that are doing this RBP, they would never go back to a traditional PPO arrangement.
Hmm.
You know,
Okay.
and Frank, I was going to supplement that real quick. I mean, think about this. Balance billing occurs more often in a fully insured arrangement than it does in an RBP plan. I don't know
Agreed.
if you yeah, seen that statistic, but you know, you got a $5,000 or $6,000 deductible, let alone copay, co-insurance, you're going to get hammered, you know, on a fully insured arrangement. So, like to your point, you're better off in an RBP deal every time,
Yep.
I think.
I do. I do too. I agree.
Uh, we've got a few more minutes here. I wanted to give a couple more questions. So, Doug, thank you for sharing the information on the Beating class action suit. Do you see that as unique, or do you see other suits developing, and do you have any others that are happening in the U.S.?
Absolutely. So, you know, there's an organization called Arnold Ventures. They're based out of Houston, and John Arnold actually came out of Enron. So he was a trader, made, you know, billions, and, you know, had to change, and now he's actually taking on funding litigation to take on health systems that have a monopoly in certain markets. So we've got 4 of these right now. We've got another one that's getting ready to be filed here in the not too distant future, currently looking both in Colorado and in Florida. So um, it's super interesting because, you know, you look at a lot of these markets. I mean, in one particular case, there was a merger. The health system had 4,200 CPT codes. The merger, there's 44,000.
Wow.
And, you know, in this particular market where you look where it is, I mean, not a lot of choice. I mean, it's like a 97% saturation of market. There's just nowhere else to go, you know, and that happens quite frequently.
Well, I would imagine that there's going to be several in the audience that may have something that's happening or know of somebody. Who is it that contacts you? Is it the patient? Is the employer? How do they find their way to you?
You know, so ultimately I do a lot of work with the Health Rosetta, which is about 280 advisors throughout the country. They probably got right around 4 million lives. That's primarily, you know, so that's the balance billing, all those different things. It's a pretty fertile ground in terms of where that activity can come from. And then it's just, you know, connecting the dots and getting people, you know, connected in the right way. And you know, it's a difficult step, you know, in a lot of these markets for a plan sponsor to be, you know, the named plaintiff, because you're going to get a lot of pushback. I mean, because think about it, you could be in a smaller market and the hospital system is your major employer. I mean, your spouse could work there. A lot of people work there. Um, it's not necessarily an easy position to be in.
Right. And Frank, from your standpoint, as a broker consultant, what advice are you providing to assist the employer clients and those employee patients?
Well, in some of these smaller markets, we find that a lot of providers, including hospitals, are agreeable to direct contracts. So it may be just physicians or those ancillary providers. It may be the hospitals, and maybe you're not going to get quite the deal that you would with RBP. You're close, but it eliminates balance bills. So we find that providers aren't necessarily opposed to direct contracts because they're not having to change their financial arrangements for everybody they have with Buca or one of those insurance companies. It's just for that employer. But my advice to employers would be to turn over every stone you can about reference-based pricing, and what we refer to and that Doug works on are unbundled, partially self-funded plans. You'd be surprised. The market, particularly the stop-loss market, has come down to meet the demand. You don't have to be several hundred lives anymore to do this, and it works much more efficiently and it's much more cost-effective.
Akram, we've probably offered over 350 events over the last 10 years and touched many of the issues that we've talked about during this session. And one of the other benefits of direct contracting is there's a big portion of the funds, whether it's the employer or the physician, that get gobbled up by Buca. and by the direct contract, you're taking part of you're saving some of that money that's potentially being lost.
The other comment, Bill, I would make is these plans that Doug works on and I work on, they're governed by ERISA. They're exempt from state insurance law. And the same organization that represented Ms. French has been to federal district court 5 times in this country. And each time the court has ruled that under ERISA, a planned fiduciary is responsible for paying reasonable charges. 140, 150% of Medicare is reasonable. Anything north of that is excessive. So it was all about balance billing the plan instead of the member. But, when you're talking about, out here and even in metropolitan areas, I can see what their charges are. They're charging anywhere from 300 to 700% of what they receive from Medicare on average.
Oh, and sometimes even more, Frank. I mean, you go to Southern California and, and even parts of Florida. I mean, I'm seeing 2,000% of Medicare.
Wow. Crazy.
Well, I want to thank you both, Doug, Frank. This has been a wonderful discussion, and we could probably go on for a much longer period of time. And but we do need to bring it to closure. And we're going to offer up to the audience if there's any questions. Please go ahead. So I want to thank both Frank and Doug for your time, and we'll look forward to questions here.